There's parallel route of litigation which is continuing for the taxpayers day in and day out. Appeal versus review. What is the way ahead?
So I think all of you would have watched this blockbuster movie RRR, review and filing of appeal, revision of orders, rectification of orders. The time limit, to the extent it is getting disposed, will get excluded. You know, courts may take years and years to close the matters.
Hello and welcome to GST Dialogues. With all the changes that is coming up in GST with GST 2.0 and other stuffs, there's parallel route of litigation which is continuing for the taxpayers day in and day out. There are orders being passed by the adjudicating authority. Few are dropped, well and good for the industry, but the options for the taxpayers is lesser when compared to the department, I would say. Taxpayers have only possibility of going on appeal if they are aggrieved with the order, but the department has multiple routes. They can file an appeal. There's also a provision on review of orders being passed by the adjudicating authority. So appeal versus review, what is the way ahead?
So I think all of you would have watched this blockbuster movie RRR. I think you might have also watched this. So something like this RRR is there in the GST law, which is review and filing of appeal, revision of orders, rectification of orders. So even this blockbuster scenario is there in the GST law, but it is only for the department. Unfortunately, the taxpayers have only 2 hours, which is going on appeal, basis the order, review and go on appeal. Second is the rectification. The second R, I think, is the most dangerous provision, which many of us are actually not focusing on, and we do not understand the depth or the extent of the powers which have been given under this provision, this section 108, which is talking about revision of orders. Sometimes I am very surprised, and I don't know, I lose words when I look at certain provisions. Whether this provision is to bypass this cases where the department have missed the bus of filing an appeal, or it is a case where this litigation will go on for years and years and we keep only fighting litigation. So this is something which surprises me many a times. And if you're looking at this section 108, it gives me even more concerns with regard to this kind of a structure. Because if you look at the time limit, normally, as you mentioned, there are different yardsticks or different limits given for department vis-a-vis the industry. Industry is given 3 months to file appeal plus a month of condonation. Department have 6 months for filing appeal plus a month of condonation under section 107. And this is an order passed by the department. So when they pass an order, the commissioner will require additional time to review the orders. Parallelly, if you look at this revision of orders, it is 3 years. 3 years for revision of an order. And this revision of order, the provision says, if an order is found to be erroneous and if it is prejudicial to the interest of the revenue, then this power is given to the commissioner again to revise the order, but the principles of natural justice have to be followed. Notice has to be given to the taxpayer, and then the proceedings will be again reopened and orders will be passed. This effectively is like replacing the hierarchy of commissioner appeals. Why I am saying so is that, number one, department, even if they don't go on appeal, they have this route of revision, and obviously it is going to be cases where the orders have been passed in favor of the industry, which subsequently department want to reverse. So that obviously they should have gone to the route of the commissioner appeals. So this is kind of a replacement of the commissioner appeals hierarchy. Number two, this order under this section 108 by the revisional authority will be issued in form GST APL 04, which is the form in which the commissioner appeals is going to issue an order. So that also clearly demonstrates that it is replacing or an alternative for the commissioner appeals hierarchy by itself. And I will obviously, once I have an APL 4 against me, even under 108, I have to go for appeal only before the GStat, which again we are waiting when it will going to be constituted. So somewhere I feel this revisionary powers have to be reviewed. Also, if you look at the legacy laws from central excise, where if you actually look at the legacy, you get some insights. There was the section 35EA, which was proposed to be included in the Central Excise Act by virtue of an Amendment Act of 1988. So again, that was proposed to be introduced, 35EA. that also has the power for revision. At that point of time, we did not have an appeal provision of 35A. It came later. I'll tell you that history. So this 35EA, which was proposed, never got implemented because in the year 2004, they withdrew that amendment. And this 35EA never got notified in 2004. So when I was doing some research, I also found out that there was a recommendation by the law committee that this 35EA is not required because the laws evolved so much from 1998 or 1988, I believe, till 2004. Laws evolved. So we also have to evolve with the times. So they said this particular 35EA is not required, these revisionary powers are not required. We have a new provision with regard to appeal by the department basis review of the order. That is when 35A, in my understanding, got introduced in the year 2005. In service tax also similar provision of revision got replaced with the review and appeal provision. GST we have a review and appeal plus a revision, which in my understanding is also there in the income tax law. So there are judgments in the income tax law which have elaborated and discussed in detail in which scenarios revision can be done. It is not that every order of the adjudicating authority can be taken through the course of revision. Dual condition, it should be erroneous and it should be against the interest of the revenue. So two clear conditions. What is erroneous has also been discussed in detail. Erroneous does not mean a difference in view. The commissioner may say, boss, I don't agree with the view of the assistant commissioner, I'll revise the order. That cannot happen. It has to be an error of facts, error of judgment on account of the law which is being applied. It cannot be a difference of view. If there is a difference of view, the alternate is only appeal. So I think we have to look at all these cases. In the event the department takes the route of revision of 108, because there are cases where 108 has been applied by the department and matters have gone till the High Court. There is one particular matter which there is a stay order. So I think that will be an interesting matter for us to look at. So I think we have to be a little more careful with this 108 because generally we are running between 73, 74, 107 and the tribunal provisions. This 108 in between, that RRR in between R is dangerous. We have to be careful about it.
So all 17, 18 orders which got dropped, there is a possibility of getting retrieved.
On a lighter note, I'll tell you, this 3-year can extend even up to 10 years. Don't be surprised because there is a catch in the provision. 108 says time limit is 3 years. But if there is a similar matter which is pending before the courts, it is similar matter. It need not be your own case pending before the High Court. Some other company's matter is pending before the High Court or Supreme Court. The time limit, to the extent it is getting disposed, will get excluded. You know, courts may take years and years to close the matters. So this can go up to 10 years. You being an advocate, I think, have a long way ahead by virtue of this provision.